In our case review, the case is between Mian Udin and Kesatuan Kebangsaan Pekerja-Pekerja Syarikat Pembuat Keluaran Getah versus Goodyear Berhad. This case discusses about the complaint of non-compliance of collective agreement. The term collective agreement explains that there is an agreement in writing between the company and the trade union of employees relating to the terms and conditions of employment. If the company fails to comply with the agreement, the employees or the trade union can lodge a complaint to the industrial court. So basically, there are three main issues that have been discussed on a complaint of non-compliance of collective agreement, which are in respect of the above. As you can see, the first one is shift allowance, the second one is annual burdens, and the last one is regarding wages or salaries. In this award case, there are three legal issues that can be found, which are the first one, whether foreign workers are covered under the scope of the collective agreement. The second one, whether foreign workers should be treated equally with local employees. And the last one is why does the respondent is not in compliance with the collective agreement. The first legal issue that can be found in this case is whether foreign workers are covered under the scope of the collective agreement. This issue is implied under Section 17, Subsection 1B and Section 56, Subsection 1 of Industrial Relations Act 1967. According to the case, there are few preliminary objections raised by the company, Goodyear Berhad. In their first ground, the company stated that the foreign workers' employment as a factory worker clearly does not fall within the scope of the capacity of workmen excluded under Section 9 of the Act. Thus, the issue arises to decide whether the foreign workers are covered under the scope of the collective agreement. In accordance with Section 17, Subsection 1B of the Industrial Relations Act 1967, it states that a collective agreement which has been taken cognizance by the court shall be deemed to be an award and shall be binding on all workmen who are employed or subsequently employed in the undertaking or part of the undertaking to which the agreement relates. Thus, this provision clearly stated that collective agreement should apply to all workmen and that foreign employees should be given the same benefits as local employees. Meanwhile, under Section 56, Subsection 1 of the Industrial Relations Act 1967, it states that any complaint of non-compliance of collective agreement may be lodged with the court in writing by the trade union or person bound by the agreement. This proves that the foreign workers are the employees of the company and have a right to lodge the complaints under Section 56, Subsection 1. Now, let us look at a few examples of related cases. According to Polyplus Package Syndrome Berhad case, the case is about the inclusion of foreign workers to come within the scope of the collective agreement between the company and the union. It was a trade dispute over the terms and conditions of a collective agreement, and the High Court had also decided that Section 56, Subsection 1 of the Act was applicable. This case is also the same as the Chonghua Plastic Syndrome Berhad and Ors case. In another case of Cocoa Industry Berhad, the issue was whether temporary employees could be excluded from the scope of the collective agreement. Section 17 provides that the collective agreement applies to all workers, whether they are temporary or permanent, or whether they are members of the union or not. Therefore, according to Section 17, Subsection 1B and Section 56, Subsection 1 of Industrial Relations Act 1967, and all related cases given, this hold that collective agreement should apply to all workmen and has determined that foreign workers are covered under the scope of collective agreement. Thus, there is no basis for the company's first ground of the preliminary objection, and the union has locus standi to lodge a complaint against the company for non-compliance.
Second legal issue that can be found in the case is whether foreign workers should be treated equally with the local employees. The issue is implied under Section 60, Subsection L of the Employment Act 1955, Article 8, Subsection 1 of the Federal Constitution, and agreement with International Labour Organization (ILO). Applying to the current case, as been mentioned in Employment Act 1955, foreign worker can be defined as employees who do not own a citizenship of Malaysia. In this case, the foreign workers are from Nepal, India, and also Myanmar. The employees in the company do not given the same benefit as local worker, which means that there is double standard between the workers. The foreign worker stand for their rights based on the collective agreement in respect of Article 22.7, 34, and also 35. The issue arose when the workers did not receive any increment as agreed in the CA. In the Employment Act 1955, it is clearly written that discrimination amongst workers based on their nationality is against the law. In accordance with Section 60L subsection 1 of the Employment Act 1955, it can be concluded that any worker, either local or foreign worker, that has been discriminated by his employer in respect of the terms and conditions of his employment may inquire into any complaint to Director General. This provision clearly stated that discrimination based on nationality are not allowed. Discrimination in all areas is against human rights. It has been stated in the Article 8, subsection 1 of the Federal Constitution, which stated that all persons are equal before the law and entitled to the equal protection of the law. This is proven that this guarantee of equality applies to all persons, citizens, or otherwise in Malaysia. Based on the case, the court also decided that the complainants come within the scope of the collective agreement no matter on what position they are in, even they are foreign workers. This is proven that this guarantee of equality applies to all persons, citizens, or otherwise in Malaysia. Based on the case, the court also decided that the complainants come within the scope of collective agreement no matter on what position they are in, even the foreign workers' job position is not clear between production operators or builders. Even the job position is not clear, there is no reason for such requirement to discriminate a certain class of workers. Other than that, Malaysia is also a member country of International Labour Organization (ILO) since 1957. In the Article 10 of the ILO Migrant Workers, it is clearly laid down that the migrant worker and nationals should be given equal opportunities and treatment. Based on the above reasons, this can be proven that all workers, either from national or local, should be treated with fairness, dignity, and also equality without distinction whether they are local or foreigners.
Thank you. Next, I proceed on last issue. The third issue in this case is why does the respondent is not in compliance with the collective agreement. This issue is implied according to the Section 17 and Section 56 subsection 1 of the Industrial Relations Act 1967. So, let's go through the cases. The first witness of the respondent, that also known as the HR Director, has filed her witness statement for the case. She stated that the employment contract that had been signed by the complainants does not contain any clause on such benefits by them. The respondent submitted that if courts makes an order to comply with the Article 35 subsection B subsection 1 of the collective agreement, then the complainants are not entitled to receive subsidized accommodation and transportation benefits. However, this matter is not compliant to the Section 17 of Industrial Relations Act 1967 that explains any terms and conditions of employment are governed by the collective agreement, as where any term exists in the individual employment contract of the complainants, which redundancy with the provisions of the collective agreement, then the collective agreement provision shall prevail. This case is referred to the Chonghua Plastic versus Idris Ali and Oz 2001, as the court stated that the granting of accommodation and other facilities cannot be considered as special circumstances excusing the companies from complying with the collective agreement in respect of wages. Next, Matter arise from the respondent is that the complainant does not have local standby to report the complaint, as he is not a proper party to lodge a complaint of non-compliance with the collective agreement as under Section 56 subsection 1 of Industrial Relations Act 1967 explains if any terms in award or collective agreement that have received cognizance by the court and has not been complied can be reported in writing to the court by the parties that have bound by such agreement. The court uphold the argument by referring to the case of Container Nasional Berhad versus Transport Workers Union 1990 that concluded the union has local standard to lodge a complaint against the company for non-compliance of agreement, but for workers who are not the members on any union and wish to avail themselves, they will have to lodge the complaint of non-compliance by themselves. After considering the decided case, the court cannot find any basis for the respondents of the preliminary objection.
After all the hearings from both complainants and also respondent sides, the final decision has been made by the judge. It explains on how the settlement of the non-compliance of collective agreements between both parties with the court order have been made. The judge decided that the respondent was not complied with the 12th and 30th CA in respect of all the complainants. The panel of employees' sides also agreed to give their foreign workers the same rights and receive the benefits that are contained in CA. Goodyear Berhad also needs to comply with the Article 22(7) subsection B shift allowance, 34 subsection A, B annual bonus, and 35 subsection A, B, C, and D wages and salaries of the CA with the court order. It has been proven that the fact the complainants are the workers at Goodyear Berhad fall within the scope of the CA and entitled to the benefit under the CA. When making this decision for this case, the court has acted with equity and also good conscience.
Adding to what we had learned, there are few types of industrial relation issues or cases heard in industrial court, which includes the dismissal of workers, application for the amendment of collective agreement, complaints of non-compliance of collective agreement, trade disputes between employer and trade union, and cases of victimization. For example, the case that we reviewed, which is between Mian Udin and Kesatuan Kebangsaan Pekerja-Pekerja Syarikat Pembuat Keluaran Getah versus Goodyear Berhad. It is a compulsive case of the non-compliance of the collective agreement between both parties, with the court order had been made. Normally, the act that will be used in dealing with industrial relation issues is the Industrial Relations Act 1967. This act regulates the relationship between employers and their workmen. Based on what we had studied, any cases for non-compliance with the collective agreement will fall under Section 56 of the Industrial Relations Act 1967. The issue arises when the employee makes a complaint about the unfulfilled deal as agreed in the collective agreement. Then, the court has to testify itself that the complaint concerns the violation of the award. If there is a breach of contract, thus it should be exercised the jurisdiction under Section 56 subsection 2. If there is no breach of contract, then no further action would be taken. Applying to Section 56 subsection 2, the industrial court will take action such as directing the parties to comply, make a proper correction of the awards, or vary the special circumstances term of awards.
As for recommendation, it is recommended that Malaysia should ensure that foreign workers who make a report on abuse and exploitation case need to be accessible for assistance and help to obtain redressals such as legal protection, temporary shelters for interpretation assistance, and the right of foreign workers to stay and work during legal proceedings. Next, Malaysia must evaluate the legislation and regulation that harm the wages of migrant workers and abolish any measures that are discriminatory concerning the right to equal pay for equal work. Moreover, it is essential that employers consent to their employees as they hold responsibilities to make sure that the employees are comfortable and being treated equally as to any agreement that applies to them. Lastly, when the matter arises have been brought to the court, the parties involved should follow the process as to avoid any another problems in settlement of the case arises, and any issues that have been heard in court must be settled through the court order.
Overall award case review, we fully support the decision made by the court, as this case clearly showed that the respondent had discriminated the foreign workers' right and by not giving them annual bonus, shift allowance and also salaries. Logically, they also work at the company and do the same day-to-day jobs same like other local employees. It is important to note that discriminatory practices can occur in any aspect of employment. It is illegal for an employer to make assumptions based on race, gender, nationality, or age-related stereotypes. It is an unlawful act for an employer to do this kind of things. This case really gives us a deep and also a wide understanding on the collective agreement and how the process of the complaint takes to the court. We can see that there are issues and problems can happen between the employer and also employees. Besides that, we understand on how the dispute is being settled between these two parties and the importance of union, which can help to represent the council to settle the misunderstanding on behalf of the employees.
That's all from us. Thank you.